Welcome to the Legal Aid Center's podcast from Symbiosis Law School, Hyderabad. I'm Malika, and today we are discussing a gap that quietly affects thousands of survivors every year. Imagine this: it's late at night, and someone feels unsafe in their own home. Nobody outside knows, and most of the law focuses only on what happens after the harm occurs. But what about the protections and support that exist before things reach that point? Domestic violence is often treated as a question of punishment, that is, arrest or no arrest, conviction or no conviction. But for someone living in an unsafe home, the real question is much simpler: how do I stay safe tonight? And for many survivors, that question isn't about filing a case, it's about protection, shelter, and stability. And the law does have tools for that. As a lawyer, a law student, or a legal personality, what we usually notice is that most public conversations around domestic violence stop at criminal law, that is, police complaints, arrest, and conviction. But what about the what the common public fails to know is that there's an entire civil law framework that's meant to protect survivors before things reach that breaking point. And that is what we're here to talk about today. To help understand this better, we are joined today by someone who brings strong on ground insight into this area: Advocate Priyajit Pandey, sir, a practicing advocate at the Patna High Court. Priyajit, sir, we are really glad to have you with us today. You work closely with civil and family law matters, including cases under the Domestic Violence Act. And I've been looking forward to have this conversation with you. And thank you so much for being here.
Thank you so much.
For everybody who's listening in, just a brief introduction. Advocate Priyajit Pandey sir practices at the Patna High Court and regularly handles civil and criminal litigation with a particular focus on family law, domestic violence matters, and related reliefs. Alongside his court practice, he is also known for engaging with the legal community through writing and public discussion, making complex legal issues more accessible. Sir, your work gives you quite a front row view of what survivors face every day. Many people don't realize that the law doesn't just punish, but it can also protect. Could you walk us through the difference between the criminal path, that is, punishing the offender, and the civil path, that is, protecting the victim? And why might a survivor choose the civil route?
Yes. First of all, thank you so much, Malika, for having me in this podcast and for the brief introduction. Uh, yes, we are having a very good topic pertaining to the protection of women who are suffering in their matrimonial life. They are having their own battle. And now, when we talk about two spectrum, one is the criminal side of it. The second one is the civil side, which you want me to take you through. And for that reason, you also want me to explain what are the things which the sufferer can do for protecting herself in that situation. Now, let's talk about this situation. What exactly happens when a person marries? A girl marries a boy, gets into the family, and thereafter she starts facing some trouble. Any matrimonial discord, it may be with the husband or with the in laws. So, at the first place, everyone tries to settle things amicably as much as possible. She does it through her own efforts, she does it by involving her parents, her friends, by mutual discussions. And even after all of it, things are not materializing. She gets out of her comfort zone and tries to do something legally, lawfully taking some actions against the husband. And there are also levels of sufferings which one might be going, and that also includes the emotions behind the person, how mentally strong the person is or not. So, supposedly, if there is a level
Excuse me.
wherein she is being harassed mentally, so that's what we talk about mental cruelty. So, when a person is subjected to mental cruelty, so now in this situation, what exactly happens that we have criminal law for it, that if you are being subjected to mental cruelty and if you are not able to manage the things, And if you are very much confirmed about it that yes, we have to take some step to safeguard, so in that situation you file a case for mental cruelty. Now this is the criminal side of it. So but we are not going that way, right? Now let's see what are the things, what are the challenges which a wife is having by staying within the same house. Now she's staying in the house and she's already facing challenges, but she is not very much open to file a case, right? She's not very much open to file a criminal case against the husband because it might disturb everything. It might even spoil the entire matrimonial life. So in that situation, she can, number one, she can file an informatory petition. So that's what we call. So if a wife is having some issue, she can at the first place file an informatory petition. She can file it before the magistrate, informing the magistrate that this is the problem which I am facing, and that informatory petition isn't going to the husband. That stays with her. That stays with her in matter of protection. Supposedly, if something wrong happens, then that affidavit can be used by the wife. So this is something which she can do. Now the other recourses are there, but you please carry on. So I'll clarify you further.
Okay, thank you so much. Thank you for clarifying the distinction. That actually brings up something we hear a lot. We often hear that many survivors don't approach the law at all because they've lost trust in the legal system. Or, from your experience, why do you think this happens? And what can we as a system do to rebuild that trust?
Yes, this fear and this hesitation, it is not only for matrimonial. It is not limited to matrimonial disputes. It is pertaining to everywhere, pertaining to all the subjects. We are not only discussing matrimonial disputes when we talk about the hesitation and fear that the law won't help. So, for that, the only thing which can be done is proper counseling, giving a better atmosphere to the aggrieved person when a person is coming to the lawyer's chamber or to whomsoever. If the person is coming with some suffering, we have to give proper counseling. We have to understand and listen to the pain and grievances. And that is why we already have a very good framework. What according to me, we already have a very good framework in a law school. We read sociology. We do read sociology. But what I feel that some significant importance should be given to subjects like sociology. We should read jurisprudence in depth. Now, why I say so? Because, see, uh, when I was in law school, these subjects were not very much considered. What I felt, we read Constitution, we read CPC, we read CPR, CRPC. We go on reading and we call it the threshold of legal system. But what impacts uh, more on the practical aspect, like when we are dealing with the litigants, now they are coming to us, and in that scenario, we should focus more on subjects like jurisprudence and subjects like sociology. Now, why I say so? It's very simple. Like the manner in which you talk to the client, the manner in which you talk to the client as an advocate, if the client is coming to you, not in matrimonial disputes, but in any other disputes as well. And when we talk about matrimonial disputes, it makes you in a more delicate position. You have to be more sensitive because it is a very sensitive topic, right? So in that situation, it helps you if you have read jurisprudence properly. What is exact meaning? Why do we have the jurisprudence? Why do we have the civil laws, be it criminal laws? What is the objective behind it? Not just law. So in many situations, when the advocate is not having any idea, when you don't have the precedents to rely upon in the courts, you take the court towards the jurisprudence. but for that you need to have better understanding. So this is my view, this is my personal view. As you rightly questioned me that what can we do, so according to me we can make sure that we read these subjects properly. The more you read, the more humble you will become, and the more, in a good manner, you will be able to talk to the client, the sufferer who is coming in front of you, the aggrieved person. Like,
I completely agree, sir. And when you said that it is a sensitive topic and that we need to study subjects like jurisprudence, I think I completely agree because in my personal experiences in the internships that I have gone through, that I have done, what I noticed is that divorce or approaching the law due to a marital discord is something that is very desensitized. Domestic violence as a whole is something that is very desensitized, but at the same time is a huge taboo to talk about to someone else that is not involved in the house life of that person, of that woman. And I think that introducing subjects like sociology and jurisprudence not only creates that kind of environment with the students, but it also sets an example for those who did not have an opportunity to study these subjects to see how the world would change, how the legal system as a whole would change if these philosophical aspects were also involved. So I think I completely agree with you on that.
yes, man, rightly pointed out. Yes.
Okay, moving on, we also hear stories about police not having enough evidence to arrest someone. So, is the burden of proof different in a civil court, or is it easier to get a protection and order than a criminal conviction?
No, I didn't get your question entirely. See, are we only talking about the matrimonial disputes?
Yes, yes.
Yes, we are. We are now. When we talk about the matrimonial disputes and when we talk about custody, police taking the husband into custody or police taking the in-laws into custody, we have settled. Now there are so many judgments. Be it Anish Kumar very in a very proper manner explains the in and out of things, right? So the gravity of the offense and what has been done and whether there is a continuity or not in that scenario, the and due to the misuse, we cannot deny the fact that though it is a law which was made to protect the women, but the misuse of it is immense. And it is an ongoing process. Like even today, while we are talking, and as from my experience, I am telling you, I have very many clients who are highly educated, having good resources, and they don't know what exactly is wrong in their matrimonial life. So I'll just give you an example. A known client of mine, she recently married 2 years ago. After her marriage, she went to Netherlands. Therein, she was blessed with a baby girl, and due to some marital discord, she is back to India. All right, and what exactly was the marital discord? Even after counseling her for an hour, she was not able to express what exactly. So it was just the compatibility issue and some involvement of in-laws, parents from both sides. So these things actually become an issue. Now in this situation, what exactly happened, that because I suggested her not to do anything, like I suggested that if you are having issues, then you can file for divorce. You go, you proceed and file for a divorce, but don't do any other thing. But again, the situation is mental cruelty. Filing a case of cruelty against the husband is a very regular business. Now, this, without telling me, the client of mine, she filed a case against the husband under the cruelty laws. Because of such incidents, which are very much regular. Now, what happened, that the gravity of this offense, as you said, that it is a sensitive issue, but it is not taken accordingly. It is not being dealt with people accordingly. And when we talk about people, it includes the bar as well as bench. It includes the advocates and it also includes the judges. So accordingly, they deal with it. So there is no particular difference, but yes, there is an issue pertaining to this law. When we specifically talk about cruelty, then in that situation, arrest is very much, it is very easy for the husband to be bailed out, though he'll be suffering, but it has become easy because of the ongoing trend. Now, when we talk about the major, supposedly if there is a case of dowry death, and when we talk about that conviction, when we talk about an FIR registered against the husband within 7 years of marriage, when the wife has died, in that situation, the proper criminal law takes its course, proper investigation takes place, and in that scenario, it is very rare that the husband is easily getting bailed out. But when we talk about this offense, when the wife is claiming for domestic violence under the DV Act or under the IPC, now BNS, that she was subjected with mental cruelty, in that scenario, the gravity has reduced, definitely. Right. And furthermore, what exactly were you trying to ask? If I am not able to clarify your doubt.
No, no, sir. Just uh, when it comes to, like you said, filing for mental cruelty, this
Yes.
is not exactly physical evidence. There is not exactly physical evidence. So, how does burden of proof work in a civil case? Like for criminal cases, there's if
But
there is
basically,
shifting.
we can't. The case of mental cruelty is not a civil case. It is indeed a criminal case. The case of domestic violence, it is not a civil case. It is a criminal case. So we can't call it civil. It is
Okay.
all criminal. So
Okay.
everything works accordingly, right?
Okay.
The only thing civil about in matrimonial dispute is when a wife files a case for divorce and when a wife files a case for maintenance,
Okay,
right?
okay. That is much more, and it's much more clearer to me now.
Yes.
Okay,
Yes.
so moving on, because criminal law often focuses on the physical violence, how does a civil family law handle emotional abuse, like you said? Uh, Emotional abuse or financial control over the abusee or coercive control. How can you get legal protection if you haven't been hit?
Not much jurisdiction is exercised by the magistrates and sitting in that jurisdiction. Let me be very clear about it. So we have to look into the law and we have to also look to the extent of jurisdiction enjoyed by the magistrate. Now let's proceed this way. Now take the criminal thing aside. Now let's talk about civil properly. Husband and wife having issues. Now, wife is saying that I am having trouble in my matrimonial relationship. Talking about my own client, which that thing happened. Now, what I suggested her that you go and please file a divorce application. So now you file the divorce application under Section 13 of the Hindu Marriage Act. Now you file it in the case, you file the divorce application, and you mention the reason. Now, what are the reasons? Why do you want divorce? So, there are reasons given in Section 13, whether it is desertion, whether it is cruelty, whether it is whatever it is, why you are suffering, whatever, you file the divorce application. Now, when you file the divorce application, you have already narrated the reasons, right? When you are seeking protection, please try to understand that when you are seeking only protection, then divorce is not the it is not the remedy which you have. Then for that you have to file a criminal case. But during divorce, you can file for maintenance. Now, what you can do, divorce being a civil proceeding, you are filing a divorce application, and in that you want the maintenance for yourself. So in that situation, you can file an application for interim maintenance, right? And that court can grant you maintenance. Meanwhile, what you can do is that if you are having issues, supposedly if the wife is having trouble, if the husband is disturbing her peace, if the husband is trying to harass her, if the husband is trying to make her go away from the case, make her abandon the case. In that situation, she can definitely file an affidavit before that court, before the family court. These are the things which is troublesome for me. And then the magistrate is holding the jurisdiction to exercise some punitive measures for restricting the husband from doing so such and such things. But at the outset, the wife cannot file a civil case for that remedy, right? That's
So
how.
I think what you just spoke about is also like popularly known as legal bullying, where an abuser uses constant custody motions to harass the victim. So, like you said, there are some punitive measures that the judges can take. So, how can a survivor protect themselves against this form of litigation abuse?
See, this form of litigation abuse. Now, in this situation, who is the survivor? Now, the wife. When we talk about the wife is the victim. She is having the issues. Now, in that situation, there is nothing which she is dealing with. There is no litigation abuse in this example. What we are talking about. Please try to further explain you what exactly do you want to question. Because in
Uh,
this scenario, the example which we are talking about, therein it is nothing like that. It is the situation. So supposedly, if the husband is doing so, and if you say it is the abuse accordingly, then nothing can be done other than filing affidavits. You cannot restrict someone from committing a crime, right? You cannot do so, no matter whatever affidavit you file, no matter wherever you go. If the person in front of you is willing to do so, then you have to file the application. You have to you have to file the complaint accordingly, and the husband will face the repercussions.
okay, that is
Maybe.
much more.
Yes, yes, yes.
Yes. Okay. So, moving on. Uh, let's say that right now somebody walks into your office fearing for their safety. What is the immediate legal mechanism that you could use to protect them? Could you walk us through the steps of getting an emergency order or something along those lines?
See, when a wife walks into my chamber asking me that I need help, I'm being subjected to cruelty, my husband hits me, my in-laws hits me. So at the first place, I'll counsel her. At the first place, I'll counsel her because she is in my chamber. So in my chamber, there is no threat. She is sitting peacefully in front of me. So at the first place, I'll calm her. I'll counsel her. After counseling, I'll see to it what what exactly is wrong in her life. What exactly is wrong in her life? People respond to uh, things in a different manner. So if the one person is Malika and if the other person is Avni, they both must be having a different level of mental capacity or the emotional foundation for themselves. So this husband is complaining, husband is doing something wrong, the mother-in-law is doing something wrong, they are threatening me, but you actually know what exactly is the situation. So you have to even ask what is the role of the wife's parents. So supposedly now there are many females who have this issue that once they are married, he is in a very peculiar condition. Now you have to see what measures can be taken. Now, after counseling, when the counseling ends, we see to it if the situation is so wrong that even entering the house, going back from my chamber, might become a threat for her life. In that situation, for immediate relief, I'll be requesting, I'll be suggesting the lady to proceed towards the Mahila Thana and register a complaint, right? There is no emergency step which I can do through court then and there itself.
Okay.
When she is having a threat of level that even going back to the house they might kill her. And if she is not exaggerating things, if I'll from whole discussion, if I'll come to the conclusion that she is exaggerating things, then I'll advise her, go back. We'll be filing a case of cruelty and we'll file it before the magistrate. We'll do it. We'll file a complaint case. But when now there are two kinds of cases also. If I may clarify that, at the first place you go to Thana, you get an FIR registered, and you can also file a complaint before the magistrate. Criminal complaint itself, that is not a civil case, right? So in that situation, I'll ask her, I'll file a complaint before the magistrate. But if the threat is that big, then I'll say directly go to Mahila Thana. Thereafter, Mahila Thana will take over. They'll call the family members, they'll call the husband, they'll call the in-laws, what exactly is going wrong, and they'll make the husband or the in-laws sign on a paper that you have to make sure that she is not having any issues in home. They'll sign it and give it to the thana. So that becomes a very big relief for the wife, because afterwards, irrespective of anything, the husband or the in-laws fears to touch the wife, right? Because then they fear the legal repercussion. When things are on paper, then they definitely fear. And even after that also, now you might even question, what is the guarantee? So there is no guarantee. There is no guarantee for us even in this podcast. You have to, these are the legal measures, and after that there is nothing left with us, right?
Yes, sir.
Yes.
Yes, I was just about to ask about the guarantee. That what is the guarantee that
No,
it
there's no guarantee. There's no guarantee. But these are the only steps which we can take. And if death is written in your destiny, then no one can safeguard you.
Yes, sir. That completely makes sense.
That's the things.
And like you mentioned that if
Yes, again, and in that situation also, if the wife is not comfortable, even after there is no push, the wife can go back to her paternal home, and if parents are not ready, in many situations the parents are not ready. Nahi, nahi, shadi hogi, you go and live with your husband. In that situation, she can even try and find a different accommodation and file a case for maintenance. Yes.
Yes, sir. Like you mentioned, that sometimes the parents of the wife won't take her back into the house and she has to live under the same roof as the abuser. So, is it possible to get a protection order while sharing the same house, or how does it work in practice?
No, that's not the only thing which we can do. Is we can we can make the husband sign a bond through Thana and through court as well. But other than that, there is nothing by which you can defenestrate the husband out of that shelter. The wife has the right to stay in that shelter, but you cannot take the husband out of it, right? And if situation is so worse, then divorce is the best option. Then there's no point to live, right? Then there's no point to live at all.
Makes sense, sir. And
Yes.
then speaking of like staying safe, financial control is another big issue. So if the abuser controls all the bank accounts, how can a victim afford a lawyer or pay rent? Or most of the victims, due to this financial constraint and social constraints, don't leave the house of the abuser due to fear of homelessness. Can the civil court force the abuser to leave the shared home? You said no. But what else can be done in a situation where the victim does not have enough financial measures?
See, awareness is important. So that's why we have the legal aids, the camps which we hold, and these things which we do. So awareness is paramount. And when the person is having the awareness, why do we have legal aid? It's not always about the financial thing, it's not about that constraint. If the girl is able to come out of the accommodation wherever she is being subjected to that control, right? And if that is the duty of the advocate, that is that therein why we were talking about sociology and jurisprudence. Now if a lady of that suffering is coming to the advocate's chamber, I am not saying that every advocate should take pro bono case. If it is feasible for the advocate, they should take the pro bono case. If it is not feasible for the advocate, they can refer to the different advocates. If it is not, even reference is not possible, they can advise the lady to go before the legal aid center. There are many options. So that's how you make the society humane. So you make the society a living place. Otherwise, there is no, it materializes. It's all about intent. If the wife is having the intention to do something legally, she'll find out a way. It's difficult. I know it is difficult if you are not having money. And when you talk about even a single penny, if you are not having, if you are not even having a money to step out of the house, then in that situation, you make a phone call. You make a phone call to the Thana. Something has to be done. Something has to be done, right?
Yes, sir.
This exactly would be my answer. Something has to be done, and the initiative has to be taken by the legal fraternity. We, the advocates, lawyers, we have to do things. If we won't, if we'll step back from our duty, because it's not always about money. You have to help people. You have to make sure that everyone gets justice. So in that situation, because that's why I say criminal law is a very responsible domain when we talk about criminal law. So again, I'll be telling you, you started by saying that you want me to take you through the civil aspect, but your entire question line is strict to it is strict
Criminal procedure.
criminal procedure. It is very responsible. It is that you have to be very responsible. You have to be very sensitive, and for that you should be having better education. Now, whenever the topic, whenever we keep on saying how to change something, we have a very good framework. Be it in school or be it in college, law college, we have a very good framework. The execution of it is not becoming possible because we have started avoiding the seriousness of some subjects, right? But it should be better focused.
Yes, I completely agree.
And I also feel that for engineering you need to have science, physics, chemistry, maths in your 11th and 12th. What I feel that I am myself from a science background, because my sister being a doctor, she pushed me towards 11th, 12th science. I don't know. But I strongly feel that it should be made mandatory that you get into the political science, you do humanities, and then you enter law. Because reading those subjects, reading about history, reading about jurisprudence, it is very, very important, and that changes your mindset.
Yes, I completely agree. It's not like the legal profession exists on its own. I think it is a it's a cultivation of everything that goes on around us.
Definitely. And specifically, if we don't understand the importance as to why these laws were made, as to how the society evolves, then it won't be possible for us. And that is the only reason why now used to we when we read the judgments, when we talk about civil conviction. Now, what exactly happened in Jolly George Varghese case? Are you aware of it? The
No,
Jolly George
sir.
Varghese case. I'll tell you that this man from Kerala, if pardon me if I'm wrong with some facts, but as far as I can recall, I'll narrate that the man from Kerala, he was convicted uh, because he was not able to pay some amount of money. All right. So under Section 51 of CPC, he was sentenced to go behind the bars. That time we were not having insolvency and bankruptcy code. So what happened? The case traveled to the Honorable Apex Court, and therein Justice Krishna Iyer was the judge. And this he was very much disappointed by the fact that though the law suggests that Jolly George has to go behind the bars, but he was not convinced. Only because he was not having money, why he should be going behind the bars? Then eventually, what happened? He went on reading UN charters, and therein he came across some convention to which India was a ratifying party, which suggested about if a person is insolvent, he shouldn't be sent behind the bars. So he passed the judgment stating therein that Section 51 has to be read in accordance to the that particular UN charter, whatever it must be. So thereafter he was released. So I say that it's all about education, it's all about reading, and when we do so, we have these landmark judgments.
That is a really great example of how, how important it is for you to not just be, sir, how they say, if you put the eye patches on the horse, it goes in a certain direction. But I don't think us as law students should be subjected to something like that. We
Yes.
should, like you said, the UN charter, we should really know what kind of example we are setting, what kind of uh, like I said, what kind of example we are setting, and we should really, pardon my language, but we should really know what we are doing.
Exactly, exactly, definitely.
So, like you said, if there are no ways for a woman to go out of the house and approach the authorities, you can just make a call. But sometimes women refrain from approaching the authorities not because they don't have the resources, but because of the children that are born out of the marriage. How do family courts balance a parent's right to see their child with the child's and the mother's needs to be safe?
Yes. Now, the question is carrying many sub questions with it. Now, when we are talking about the Guardianship Act as well, we are talking about the maintenance part as well. So, it all depends upon the scenario. So, at the first place, if she is hesitating to take legal recourse because of the child, it is a principal matter. The wife is having that thing that okay, the child is very small, let the child attains the major age, and thereafter she'll be taking actions. This is a general trend. People do so accordingly. You have many cases wherein the wife approaches and intends to take legal recourses when her son or daughter becomes self-sufficient enough even to maintain her. And when she wants to take legal recourse while the son or daughter is minor, then in that situation, she is not having any other remedy than to approach the court and file a case for maintenance. She can file a case for maintenance. Now, for filing a case of maintenance, you have both civil and criminal remedy. In CRPC, you have that remedy. Under Section 125, you file it for the maintenance. And then in the Special Marriage Act or the Hindu Marriage Act, you have the again maintenance provisions. So thereafter, when the maintenance case is being filed, the court looks into the aspect that who is taking care of the child, and accordingly, the court takes the decision in considering all the aspect, considering the so income affidavit has become mandatory. So whenever there is a case of maintenance, both the parties have to file their income affidavit, both husband and wife, and also the expenses which they have to make. So accordingly, the court comes to the conclusion, a just conclusion. And if the court is not coming to a just conclusion, and if either of the parties aggrieved, then the party can approach against the order of interim maintenance, they can approach the High Court. So that is something which can be done.
Okay. So in this period of waiting till the child reaches a certain self-sufficient age, uh, I mean, there are women who aren't ready to leave due to this reason, but still want to prepare for the case that they will be filing once the children have reached a certain age. So, is there any sort of evidence that they should be gathering, like screenshots or maybe recordings, something that actually holds up in court?
But it brings me to a very pertinent question which I'll be putting before you. That what must be the objective? See, the objective has to be figured out. If the wife, if the wife suffers through so many years, waits patiently for her son or minor to grow up, become self-sufficient, then at that point of time, what exactly she might be looking for her to gather the evidences for so many years? She just want to go away. There is nothing other than that what she requires.
Okay, okay.
So what is the purpose of gathering evidences? It will only make her crazy. It will only make her more upset. There is no question. So again, I'll take you. What is the objective? What the wife wants? If the wife wants the husband to be punished, she didn't do so in so many years. She should have done that before. She considered the child. Now, when even she is doing at that point of time, when the husband, he might be very bad, he might be very, if she is living with him, then definitely the husband is not killing her. He might be very annoying, he might be very bullying, he might be very threatening, he might be whatever. But if she was able to spend almost 20 years with him, in that situation, the wife cannot say that put him behind the bus, because at that point of time, the husband must have taken care of so many things, the education, the he must have made sure that the son or daughter became self-sufficient because of the things which the husband did so. Now it is better that in that situation the wife should just get out of the house, and she can definitely at that point of time also she can ask for maintenance, alimony, maintenance, whatever she requires. And for that she is not supposed to make any evidences for herself.
Even in a case, in a case where a child is not involved, or if she does not have to wait that long,
Yes.
is there no need for evidence to be gathered at all?
Objective, that's what I'm saying. What is the objective?
Object.
What is
Okay.
the objective? If the objective is to put him behind the bus, if the wife is happy with him behind the bus, with him being behind the bus, she has to gather evidences. So that's what I suggest. That's how I counsel the wives when they come to me. That please tell me your objective. Will you be happy by sending him behind the bus? Will you be happy by being away from him? Because see, it's not just putting someone behind the bars is not a one-time thing. So supposedly I'll tell you how it takes place. You file an FIR against the husband or a complaint case. You put the husband behind the bars. You gather the evidences like Sherlock Holmes, and you have gathered the evidences. You have made sure that this person, he hits me, he did that with me, he choked my neck, he tried to kill me, he did so and that. Would it be the end of the tale? No. What happens thereafter? The trial takes place. The trial goes on for 10 years. The wife has to time and again come to the court. So, whether the wife is ready for those sufferings, you have to know the objective. When we talk about these things, we should talk responsibly. That's what I'm saying. What your question line is, when we talk about gathering evidence, I say why. If things are that disturbing, just go away. Go away, live your life. Why do you have to unnecessarily? So I'll tell you, there's another client of mine. She is having a 12 years old daughter. All right. And that pretty girl always comes to the court for mediation rounds. I keep on requesting my client, please stop it. Please stop it. Go. तो she says, सर मेरे पास तो कुछ काम नहीं है ना अभी. मैंने बोला, you are self sufficient, you are educated, you can start your day even today. And the husband on the other side is even ready to pay maintenance, alimony, and everything. I say, don't go for maintenance, go for one time settlement, take some money, fix it for your daughter. And the husband says, it is only for her, I'll take care of the daughter till the time she gets married. But then also, no. And when I ask what is the objective, there is no clarification to it. So the thing is that we should look into the entire matrimonial dispute in a responsible manner. And we should just try to brush this issue aside as part of the legal fraternity, be it advocate or be it a judge. There is no question of advising any. If the husband is bad, if the husband is drunkard, if the husband beats, whatever it is, don't live with the husband, right? That's what I say. That's how I feel.
I completely agree, sir. There was a statement made recently in a matrimonial dispute. I don't exactly remember who the justice was, but he said something like, a marriage is not just a duty to the society, but it is also a relationship between the two people. And what usually happens in marital discord cases, even in the judgments that are delivered, is that the bench views it as not a relationship but as something that could set an example for the community as a whole. So, do you think this approach towards situations like this is something that we need to change?
No, I don't. I don't think accordingly. It is case to case. There is no fixed narrative towards it, and there is no fixed. There cannot be any proper opinion to it. Our history is so vast. It is so vast. If you read this book, An Ode to Fraternity, authored by R.F. Nariman, it is a classical book. And being a Hindu, I am telling you, that book told me about myself what I wasn't knowing before reading it. I never read the things written in that book in school, never read it in my college. And hats off to that man. He has authored that book beautifully, right? So it talks about Rig Ved, it talks about Upanishads in such a plain language. And when we talk about those things, the things mentioned in those pages, I'll tell you, just reading a commentary, that is only a commentary. He must have read it and he has given his views. That commentary is so beautiful. Now you say what must be the original texture. So there is no fixed opinion. I don't consider everything is case to case. Every person is having their own issues in life, their financial position, their family members, how their family members are responding to their concerns, whether the wife is having supporting parents, whether the wife is educated, the city in which the wife must be living. So, a wife living in Patna and a wife living in Mumbai has a very different equation. And you cannot hold them equal on an equal pedestal. You cannot do so. So I don't agree to such opinions. It cannot be. It has to be case to case wise.
Yes, sir, I completely understand. So, moving on to our final and a very important question, I believe. If I can't afford a private lawyer, where is the first place I should look for civil legal aid?
We have nowadays in every institution, even I'm part of Patna High Court. Even in Patna High Court, we have the legal aid center. The litigants can directly approach the places and ask for legal aid help. We have legal services authorities in districts. They can move before those district legal aid authorities. So there are options. And at the first place, what everyone should recommend, that go to the advocate, even if you're not having money. The advocates, the this profession is a very noble profession. Definitely, we earn money, we mint money. That's not an and that is something which we have to do. But even the highest paying lawyer, the lawyer who is being paid the highest amount must be in the country. They are also humans. They understand the pain. So every litigant, we should promote everywhere that you please go to the advocate. They'll listen to your pain. Definitely, you cannot get into the chamber of a senior advocate very easily, who must be having the consultation charges and everything. But there are so many advocates. You go to them, you approach them, you will get help. We are from a very noble profession, and I'll tell you a very small example of myself. It was year 2020, COVID times. All right. Uh, my staff, I even wrote about it. Um my staff was the maid who was working in my home. Now her husband was an FIR got registered against him. Okay, I filed an anticipatory bail. The anticipatory bail in the High Court, from the District Court, it got rejected. And before the High Court, it was pending since 4 5 months. It was not being able to be taken up because of the pendency of cases, huge pendency of cases. And the COVID time came. What exactly happened? That one fine day, the police approached the home of my maid. They got the husband. They took him into custody, and his wife was 9 months pregnant. She was not even a named accused in the FIR. The police took her away also. Okay, along with the husband, the wife was also behind the bars, and she was taken into custody on 5th of May 2021. I still remember. 5th May 2021. And on 7th of May 2021, she delivered in judicial custody. A baby boy was born. I filed the case. I wanted to file the case before the Sessions Court for securing bail, regular bail application. But that was the only time when even online filing was closed. So no option was available even in Sessions Court. No option. Leave about the fees. They were very poor. No penny. I was having this duty because it was something that home staff and everything. I'm not saying that I'm a very good person that I keep on taking free cases. I did so because it was my responsibility. Thereafter, what happened? I filed the case in High Court. When I filed the case in High Court, I even directly filed the case in High Court, because when you file the case in High Court, you need to have the rejection order of the Sessions Court. Without there being any rejection order of the Sessions Court, I filed the case in the High Court. I mentioned the case in the High Court, it got rejected. Because that time, even the High Court was not accepting any case. That was the most alarming period, more graver than the 2020 lockdown. So in 2021, many people died. Actually, that time the COVID was it was in a very alarming stage. Now, what happened? I had no scope left other than filing a case directly before Supreme Court. Trust me on this, Malika, that I approached 3 4 lawyers in Supreme Court. All of them agreed to file the case. All of them. No one said no. I'm telling you. So we are very humble people. We are having a very, we are humans. We consider the pain. We consider the situation. That was a very good thing which happened. I even wrote about it, that it's such a noble profession. Thereafter, another twist took place. The Supreme Court advocates, they requested me, please send the wakalatnama from jail. So from jail, you sign, you get the signature of the person in custody. So for that, what happened? The jail superintendent said, "How can we allow signing of wakalatnama of Supreme Court without there being any rejection in High Court and Sessions Court?" Now I was like, now I have to explain him jurisdiction. I have to explain jurisdiction to a superintendent. But thankfully, everything happened. The district court filing opened. We filed the application, and the bail was secured. So now I'm not saying, I'm saying four persons. I approached four persons, all of them agreed.
So that is really delightful. I think stories like these really build back your confidence into the system.
Yes, definitely, definitely. Let's try to make an positive atmosphere everywhere. Why to say negative things? Let's not say negative things. We are living in a very good country. We have a very good bar. We have a very good bench. And we, as part of legal fraternity, are doing wonders in the society, and we'll be doing wonders. The only thing which we have to do is we have to study properly. The basic education shouldn't be ignored, and we should keep reading as much as possible, and stay away from social networks as much as possible, and we are good to go.
Yes, sir. Is there anything that you would like to share to the law students? Any piece of advice?
No, I think so. I have already said many things.
Yes,
So
sir.
I leave it here only, and I just wish everyone uh, best of luck for their future. Best wishes from my end for all the students studying in Symbiosis. And yes, thank you so much, Malika.
Thank you, sir. Thank you. Thank you so much for walking us through all of this today. And I think it's pretty clear to all of us now that the law isn't just about punishing people, but it can actually provide help and protection for survivors who need it. And for everyone listening, the main takeaway is that support exists. There are legal tools available like protection orders, you mentioned emergency financial help, and ways to deal with emotional or financial abuse, as well as measures to keep the children safe. The law is always there to survive, to give survivors options, even when the situation feels overwhelming. And we hope that this conversation helps shed light on these often overlooked parts of domestic violence law and reminds anyone who might be struggling that help is out there. And like I said, so this is a topic that's often normalized, and in some ways, people have become desensitized to it, even though it really shouldn't be. So let's hope that today's conversation helps people see it differently. I realize that support and help are available, and think about safety before it's too late. And with that, we'll end today's discussion. Thank you again for sharing your insights with us today. And we'll take this wisdom forward and hope to put it to use, while also hoping that none of us ever find ourselves in a situation where such a conversation becomes necessary in the first place. Thank you so much, sir.